Hi, everyone, and welcome to the National REIC podcast with myself, John Zwirzina, and Jeff Green. Jeff, how are you?
I'm doing great. I'm here in sunny South Florida. It's not so sunny today, but we'll live with it.
All right. Today we have two of the top real estate attorneys in the state of Florida, Jimmy and Evan Miller. How are you guys?
Oh, we're doing good. Trying to stay dry with the way the weather's been today.
How's your weather up there in Philadelphia, John?
It's rainy up here as well.
Always rainy in Philly.
Yeah.
We have Jimmy and Evan Miller. It's my great honor. I've known Jimmy and Evan Miller for quite a while. We've done a lot of business together, and we're so excited to be participants in the Sunshine State title. Jimmy, please tell us about your background. It's very extensive, and let us know about it.
Well, for about 35 years, I was the attorney for most of the boards of realtors here in Palm Beach County. And so that let me sit in on lots of hearings before the board and act as their general counsel. I chaired the Florida Association of Realtors Realtor Attorney Committee and chaired the FAR Realtor Attorney Committee for a number of years. I've done somewhere around 44,000 closings at this point in my career. At one time I had 27 title companies. I was the original designer of the controlled business arrangement, which allowed title agents to have partners. And for 10 years I had the largest firm defending real estate agents in the state of Florida. So we would get between 100 and 200 claims a month. So that let us try cases from Pensacola to Key West. And in, 1997, I think it was, I was chosen by the insurance industry as the best lawyer in the United States at resolving claims against real estate agents. So
there you go.
What was the biggest bad activity agents would do?
Most times in Florida, we have a case called Johnson versus Davis, a Florida Supreme Court decision, which puts an affirmative duty on the seller of real estate to disclose any and all material factors that affect value. So most of the cases, I would say at least 95%, were when someone would purchase a property and discover something they didn't like about it. They would then go back and they would usually sue the seller and the real estate agent, saying that had they known about this particular issue, they would not have bought, and that it was a material factor in their decision. And so what you ended up dealing with was one, if you were representing the real estate agent, did they know about the condition? And if they did, they also had a duty to disclose it. And we had a problem to deal with. But in most cases, we were able to get the cases resolved by proving that the agent didn't have any knowledge of the conditions. Let's face it, the agent is a marketing person, does not reside in the property, doesn't have a general contractor's license, a surveyor's license. A lot of them were AC problems or leaking windows. They aren't licensed in those particular areas. So unless they were told by the seller, they wouldn't have a way of knowing about problems like that somebody that's there daily or frequently would have an idea of. So we were able to get most of those resolved, and that's how we got the award. We got pretty good at it.
But isn't it buyer beware and as is contracts and hide as much as you can and not in this world?
Prior to the Johnson versus Davis decision, that was kind of the rule of the law. And then the Johnsons and Davises were one where the buyer signed to purchase a property, an as-is property. The seller didn't disclose that there had been a previous infestation of termites. The buyer learned about it after their inspection and wanted their deposit back. The seller said, nope, you signed an as-is contract, it's your problem. And the buyer went all the way up to the Supreme Court who in Florida said that the purchase of somebody's residential home is probably the largest single investment they will make in their life. And if the seller is aware of conditions, they have an affirmative duty, even in an as-is contract, to let the buyer make an informed decision. So they have an affirmative obligation to disclose. Now, just so to be clear, it only applies to residential transactions. If it's a commercial property and commercial transactions, the court's later decisions have said that anybody buying and selling commercial property generally has a little more sophistication and knows how to protect themselves. And Johnson versus Davis, the seller's obligation to disclose does not exist.
Well, I have a question. I like working with my two sons. I like working with John. How is it working with this genius that you have made, this guy Evan Miller, that was #1 in his class? How you doing, Evan?
I'm doing good. Doing good. And I can answer that for him. It's fantastic.
It is good to work with family. I tell you what, they always have your best interest in mind.
It is. It's really been great. A little bit about my background. Before I decided to become an attorney, I actually went to and did my undergraduate work at FAU down in Boca and got my bachelor's degree in real estate and finance. And I got to tell you, this was during the height of the crash. So it was an incredibly interesting time to be studying real estate, because all sorts of assumptions that they thought would hold valid had changed. And most of my professors were just happy to have a job in real estate at that point.
It was the great crash of 1929 and 2008 or 9, whichever way you look at it.
Yeah.
So, John, I believe you have a question.
Yeah, so let's start this thing off by talking about probate. So why don't you guys explain what a probate is for those who don't know?
Probate is a fancy term for a simple process. Basically, when somebody passes away and they hold assets in their name, so I own a piece of property, it's in my name, and I've passed away. Well, we need a process to transfer that to whoever I've designated, right? Or if I haven't designated anyone, whoever the state has designated. And probate is nothing more than the legal process. It's a court action process of transferring title from a deceased person's assets to their beneficiaries. And of course, the other interest holder in that process are the creditors of the deceased. So the fundamental purpose of the process is to ensure that the creditors are taken care of when someone passes away and transfer the title of the property. It comes up quite a bit in the real estate investing context because particularly in South Florida, we have a significant number of a large elderly population, and there's a significant transfer of wealth when all these properties get passed down to their children. And particularly in South Florida, a lot of the children are out of state. And they are suddenly, you're living in New York and suddenly your mother passes away and you've just inherited a home in, Boynton Beach and you're unsure what to do. That's typically where we come in.
You can call us. That would be a great idea because we do buy houses, and we've been calling a lot of probate people lately and helping them because the kids don't want to come down south. They just want money, money, and that's what we give them. So why is it important on a probate to establish Homestead?
Well, fundamentally, there's two different processes. If I'm the investor and I'm looking to sign a contract on a probate piece of property, the first question is always, well, who can sign the contract? And really the answer to that question depends on whether the property is homestead or not. A lot of people are aware that Florida has a special designation for homestead property, and in the probate process, that holds true as well. Homestead property is exempt from those creditors' claims. So if you've got, $1 million of medical bills, none of that's going to affect the transfer of your homestead, pending that it passes to your family. And with homestead property and the process of going through and getting a homestead determination, when the probate court says that a property is homestead officially in something we call an order determining homestead, it says this property does not belong to the estate, but in fact belongs to the heirs. Where typically a second property, let's say, or an investment property that belongs to the estate would be handled by the person we term in Florida as the personal representative. Most states call it an executor or executrix, but we've gone with the gender neutral personal representative.
Mm-hmm.
And that person is basically a representative of the deceased who's been appointed by the court. They have all the legal authority to take action as the deceased would. In the case of non-homestead property, that's the person you're going to be contracting with. They're going to be the one who has the authority to bind the estate. And basically their job is to go through with the transaction, get that large pile of cash and pass it out to the designated individuals, whether that be beneficiaries or creditors. Or with homestead property, the court is saying, this is not property of the estate. By law, it passes to these people here. In which case, let's take, for example, someone passes away, leaving their homestead to their son and daughter. In that case, when you're getting your contract executed, you're going to be looking for the son and daughter both to sign on that contract because the property really belongs to them and ultimately not to the estate. So we see quite a bit of issues with that where people go, oh, I contracted with the personal representative and now the 10 other beneficiaries are saying, 8 of them are saying they won't sign. And in order for us to get to the closing table and to ensure the title on that property, on homestead property, all of the heirs are going to have to sign.
All right.
What if there's a minor involved?
Well, the one thing, the caveat I'll put in there is if they left home, even if it is homestead property, they've lived there for 80 years and they die, but they left it to a friend, it does not get the status of homestead property. So you've not only got to look at the property and the nature of it, but you also have to look at who they're leaving it to. Because the homestead only attaches to relatives that are the ones that are receiving the property.
Wow. I'm really happy you guys know what you're doing.
And Jeff, to answer your question, if there is a minor involved, it gets a little more complicated because you have to have a guardian appointed by the court to make decisions on behalf of that minor. So it's a potential another court process because if the minor, under Florida law, if a minor, someone under 18, is inheriting more than $15,000, they're going to have a guardian appointed to handle those funds.
Well, how do you know if you even need a probate?
The first step would be to contact someone like us and have us look at the title of the property. The key in with whether something has to be probated or not is the property remaining in the deceased person's name at their death? There's a few different types of ways that you can own property, particularly joint property. The first of which is something called tenants by the entireties. It's a special form of ownership that's afforded to husband and wives only. And obviously, in modern times, husband to husbands and wives and wives. But it says that in the event one spouse passes, the property automatically passes by operation of law without probate to the surviving spouse. So a lot of times you'll see this written on real estate documents. It'll say, Evan Miller and Joelle Miller as husband and wife. That's it. You think, wow, well, why is the fact that they're married important to the document? But that's actually stating the form of ownership. The second type of joint ownership you can have is something called joint tenants with rights of survivorship. And that you will see spelled out as, let's say, Evan Miller and Jimmy Miller as joint tenants with rights of survivorship. And under that type of ownership, again, no probate. It's going to pass by operation of law whoever the survivor of us. It sometimes creates interesting situations in which people gamble on who's going to live longer. Because if he passes away first, the property becomes 100% mine, and if I pass away first, it becomes 100% his. The third type of joint ownership is called tenants in common, and that's the default form of ownership. If you don't designate either joint tenants with rights of survivorship, or if you're married, tenants by the entireties, then you own property as tenants in common, which means when you pass away, it will remain in your name. Let's say it's Evan Miller and Jimmy Miller. There's no other language in the documents. By default, we would each own one half of that property, and if either of us were to pass away, our portion of ownership would have to be probated.
But you guys do estates and wills, so it'd probably be smart, 2 brilliant attorneys, not even owning a title company, but you have Miller Legal as well, and this is what you guys do. So you're saying that prior to a probate, if the people get a hold of you, there's other ways that you can do it to avoid the probate?
Yes. And as an aside, you don't have to go through probate if you do a little bit of planning while you're alive. So for those of us still here with the living, it's a good opportunity to do a little planning to avoid having to go through that process, just because probate can get expensive and it can cause a delay.
Now, part of the problem is that the average cost of probate in Florida is roughly 7% of the gross estate. Notice I said the gross estate and not the net estate. So if I've got a property, a $500,000 property, and I've got a $490,000 mortgage on it, my estate is going to have to pay the probate fees based on a $500,000 value, although I only have $10,000 of equity. So a lot of time, and if you do the math, that's $35,000. Just if that's the only asset they've got.
Well, so what if I don't have any money? What if I don't have any money and I'm trying to do a probate? And I know you guys are investor friendly, but just how friendly are you? How can you help me if I got no money and I want to do a probate?
Well, with some attorneys, us being a member of the group, but most attorneys will not do this. But a lot of attorneys, you have to have the money, right? This is the retainer, and it is what it is. Where we work with investors to get paid at closing on those type of transactions. You have to pay the filing fees, which are our hard, direct costs to the Palm Beach County clerk, or whatever county we're probating in, because we can handle anything throughout the state of Florida, which are typically around $500. But we don't charge a fee on the actual administration of the estate, that percentage fee, until we get to the closing table.
Okay.
Well, what if I was trying to scare some money together and I had some stuff in there, like maybe bank account, a car? Am I able to get any of that liquid to pay you guys?
Correct. You can definitely use the assets of the deceased. You don't have to come out of your personal pocket to advance those funds.
Perfect.
Most people have a checking account, or somewhere that they kept some amount of money.
John?
Yeah. So the next question I had was, for those that don't know, explain the process why you can't buy a probate for too far under the value, and what can the investor give you to help prove the value of the property?
Part of the problem there is that if it's non-homestead property, any contracts that come in during the process of probate have to be approved by the court to approve the sale. Now, the timeframes that we deal with in that, a person passes away, we have to open an estate. The court may approve a sale pending creditors' claims, but most times they're not going to until after the creditors' claims period is run, which is 3 months from the date of first publication. So what happens is the court will look at the contract. I know in our county, it varies from county to county. Not only do we have to provide the contract, but we also have to provide the property appraiser's appraised value or tax value to show that it's close to the same price. if we're going to try and deviate from it, we have to provide justification for it because the judge has to approve it. And typically they will not approve unless you've got some good justification. At minimum, the property appraisers determine value because, as we all know, it's generally a little bit lower than what the fair market value of the property is. So we would ask them to look at the nature of the property as far as helping us out to see exactly where their offers are coming in. Now, if you're dealing with homestead property and you've got the beneficiaries that are going to sign off on it, then in that case, the court doesn't scrutinize the price, and it's an opportunity to maybe buy it at a better bargain price than you could in the other scenario.
Wow, that is good stuff. That's a great tidbit there.
Yeah. How long does the actual average probate process take?
Well, it depends on the type of process, but for a formal administration, typically is 12 months, right? That's not saying you have to wait 12 months to close on the property. That's just saying from the start of the estate to the close, you're looking at about a 12-month period. What we see a lot from the investor side is people have estates that own nothing but a piece of homestead property, right? They have all their bank accounts and everything are joint. The only thing they have is their individual homestead in their name when they pass. So in that case, there's something called a summary administration, which is an expedited process that if the person has been deceased for longer than 2 years, or if the total assets of the estate are less than $75,000. But the kicker with that is we do not count homestead. That's exempt. It does not count towards the $75,000. So you say, I've got a $300,000 homestead and no other assets. Well, that homestead property is exempt. So technically the value of the estate is zero, in which case you could file that as a summary administration. And after that 90-day publication period, close out, be able to transfer the property, then have a closing, and be able to close the estate and after those 3 months.
Okay.
So it's an excellent opportunity to speed things up if you qualify. And the reason for the distinction of 2 years is after someone has been deceased for more than 2 years, all their creditors' claims are barred. Right, you can't make a claim against an estate that's 20 years old or something. So it's just their way of saying, hey, there's not going to be any creditors because it's been too long.
Gotcha.
That's good stuff.
All right, Jeff, you got something?
Oh, I do. What types of deeds are there? I keep hearing these different things about a warranty deed, a quitclaim deed, and all this different stuff. I want to go over that a little bit and kind of give us some insight. I mean, everything you've said is brilliant so far, and I'm glad you know all this stuff, and that's why we use you guys. So go right ahead.
Go ahead.
Typically in Florida, we see 3 different types of deeds used. There's some others, like a grant deed, that is used in some other jurisdictions. It's almost like a right of first refusal. It ties property up so they can't do it, but Florida does not use that as a rule. So we have the warranty deed, which they call it a warranty deed because the seller is warranting that they have good ownership of it and that they are conveying good title to the buyer. It's the most common form you see used. A lot of times then the other type is a special warranty deed, in which they have removed some of the various warranties of ownership and changed it. You see a lot of developers use that to limit their trailing liability after they've sold the property. That's probably the most common that you use from a developer. The third that you often hear talked about is what's called a quit claim deed. Not quick, but quit. And a quit claim deed does not carry any warranties. So this person that's signing that, the seller in that deed, is basically saying, I'm giving you whatever I have. I'm not warranting that I have anything, but I'm giving you whatever I have. So for example, our offices are down on the old Forum 3 buildings on Palm Beach Lakes. I could right now sign a deed over to Jeff in the form of a quitclaim deed, and I'm basically, you know, if he records it, it's going to look like he owns the office building where our office is located. However, there's somebody else that has an actual warranty deed that is the priority owner. And a lot of times people confuse that and think that, oh, it's a quitclaim deed is something I can get very simply. And unfortunately, most people don't realize that if a quitclaim deed is used, it cuts off any title insurance that may have been issued. Most title insurers will not issue over or after a quitclaim deed is doing because they've not had any warranties that they're providing coverage for. So those are the three primarily types that we run across in Florida. I think there's one other in there.
Yeah, bargain and sale deed, which is kind of like it's basically you're transferring the right to sell the property in the future, but you're not making any guarantees about the title. Again, similar to like a quitclaim deed. So if you think about it, the two real types of deeds that could, particularly for investors, because a lot of times people will come to them and say, hey, you know, this guy, he wants me to give him, you know, $10,000, then he'll give me a quitclaim deed to this property, and it's a great deal. And they don't understand that it's basically just saying, if I own any piece of this, I'm giving it to you. It's not, there's no guarantee that they own what they're selling you. Or with a warranty deed, particularly a general, we'll use the term general warranty deed, warrants, I'm guaranteeing that I own this and that the title is clear, you know, back from the beginning of history. Or with a special warranty deed, the distinction is it's saying, I'm guaranteeing I own this today. I'm making no guarantees about, you know, what happened 100 years ago.
So a quitclaim deed is basically subject to everything, subject to liens, code enforcement, subject to basically have the deed, but it's ownership, but it's subject to everything else.
Yeah, and it's one of the problems that you run across, and it's one of the reasons that you need to do, you know, title insurance if you're the buyer, is because that doesn't tell you whether the person you're actually dealing with is in fact the record title holder of that property. One of the things that when you get title insurance is the title company goes back to the public records and searches years back to ensure that the person with whom you're dealing actually has actual ownership of that property. And if anybody, and it lists in it, any exceptions from coverage. And what that does is if anybody else comes in and claims an interest in that property, that title insurance policy will either compensate you for the reduction in value that may cause it if it's legitimate, or they will provide defense coverage and defend your ownership interest in court at their expense to get that removed.
I think a big thing with him talking about title insurance, because people get caught up in the deed aspect. So correct, a warranty deed would be me warranting, let's say, that I own this property, you know, and that the title is clear through all back through history. The kicker being that the warranties are only worth what the person making them is worth, right?
Yeah.
So I can give you a warranty deed, you know, to the Empire State Building, and you can feel great about yourself. And then when you find out I don't own the Empire State Building, you have a valid legal claim against me. But at this point, I've taken your, you know, $100 million and flown to Tahiti, and you're never going to see me again. That's where title insurance comes in to make sure that everything is in place and that all the kind of I's have been dotted and T's have been crossed before you get in that situation and the funds are transferred to that person.
We don't do closings on the hoods of people's cars anymore. No more.
Well,
back in the day, that was.
I can tell you a little story about that too, just to show you how tough it can be and how confusing it can be.
Yeah.
A few years back, I worked undercover for the Florida Department of Law Enforcement, and I say undercover. What had happened was they had discovered there was a ring. And what this ring was doing was, this was back when mortgages were easy to, you know, obtain. They were finding properties, generally close to $1 million in fair market value, with an absentee owner or a seasonal owner. And they were properties that did not have a mortgage on them in most cases. And what they would do is they would have somebody forge a deed in a fictitious person's name. Of course, it was a warranty deed, and they would record it. They would then go in, change the locks, and take over possession of this. Now, because it was an absentee owner, they had no idea that this had taken place. So they would then turn around and go to their local lender and say, hey, I've got this property. It's worth $1 million. You know, I got something I want to do. I don't need $1 million, but how about giving me $500,000 against my $1 million property? Well, when they did a title search, what comes up? Their warranty deed shows there. It's unencumbered. It's in their name. They appear to be the actual and rightful owner of the property. Sometimes they were even getting title policies issued. And of course, they would get the $500,000 and they would disappear. They anticipated they got away with somewhere between $70 and $100 million pulling this scam around South Florida. The reason I was brought into the case was because they were afraid that these people were fairly sophisticated with the real estate system, and the law enforcement officers were worried if they made a misstatement that these people would get wise and they would not be able to catch them. So we actually had a transaction where it was found out, fortunately through a friend, that this was taking place, a mortgage officer who got suspicious. And we actually set up a closing in my office. And I brought in the undercover law enforcement officer and introduced him as the new closer I was training. We went through the entire closing. We gave them the checks. They got their money. Outside in the hallway was a complete SWAT team. I had my staff leave the office, and they were able to catch the group. But that's how sophisticated and how easy it is to get tricked if you don't know what you're looking at.
Yeah.
There was one type of deed that you didn't cover. It's called the corrective deed. And I've done deeds way back, 20 years ago, and you forget to put the marital status, you forget the witness, you forget something. So now we have the professionals do it, and it's done right every time. So Jimmy, you're an expert witness, I hear, through the grapevine. You've been doing some of that stuff?
I've done quite a few of those. I've been qualified on multiple occasions by other attorneys and the judges in different parts of the state as an expert witness. They usually say an expert is somebody that's more than 40 miles away from their home, but I've actually been an expert here in my own hometown.
That's good, though. I mean, you're very well respected, and we're very happy to be in your midst.
All right.
What you got, John?
So I got a question for Evan. Evan, so you were talking about title insurance and everything. What is title commitment, and what should the buyer investor look for?
So a title commitment is the document from the title company that you're going to receive during the closing process, right? It's the title insurance policy will ultimately be issued after the transaction is closed, but the commitment is them saying, okay, we're willing to issue you this title policy with the following exceptions pending that these requirements are met. And typically you get given this at some point during, while the closing is pending. And it basically lists for you what the exceptions to coverage on that policy are going to be. And there's some standard exceptions, but a lot of them are specific to that particular property. Let's say, okay, for example, on my own personal residence, there's an easement across the back of my property for utilities. Right, FPL has the right to run lines or Comcast or something. It's fairly typical, and that's listed as an exception in that commitment. It says we are guaranteeing you that you have complete 100% ownership of this property, but we are not guaranteeing you that FPL and Comcast don't have a right to use it, because in fact they do. It's recorded in the public records. So when you get that title commitment, the first section, there's really two sections that are listed under Schedule B of the commitment. The first of which is the requirements. And that's basically a list of items that have to be taken care of before the closing or at the closing. It might say, you know, the more you need to satisfy this mortgage that's outstanding on the property. And the title company will work to, I mean, that's a title company's job, is to work to ensure that all those requirements are fulfilled at closing or before the closing. And that the second section that's listed as Schedule B-1, or it's a Roman numeral, looks like BI. And the second section, which lists those exceptions from coverage, is Schedule B2. And you always want to look at that commitment, because if there are exceptions in there that you're not comfortable with or that you should think should be removed, you should communicate that to the seller of the property along with the title company, and you can object to the title. Say, hey, I'm not willing to live with this. This is not clear title. And you have to make that objection. You know, if you look at your real estate contract, it gives you a timeline of when you can make those objections. And you want to make sure you're making them within the time frame you're allotted so that you can get your deposit back and get out of that contract if they're not able to resolve that title defect.
Okay. And well, and one other question real quick while on the subject. What if my home value increases, my home increases in value? Am I still covered for just the amount of title coverage that I have, or does it go up in value? Or
it does not go up in value. You're covered for whatever value policy you've purchased. So title insurance is a little bit different. Unlike homeowners insurance or something, which you pay every year and it's constantly changing, the title insurance, you're really purchasing the policy in a one-time transaction, typically at the closing, but that doesn't necessarily have to be the case. You could always, of course, buy a policy after the fact. But you're making that one-time payment and you're purchasing a policy for the value stated on the first page of the title commitment. That title commitment will say, you know, the policy to John Zwirzina and National REIC for $100,000. And that's going to be the limit of the liability that the title insurer is covering you for. I think it's important to understand that title insurance policies, a lot of people know title companies. Oh, I've got one a friend that works for a title company. They're generally not the ones issuing the actual policy. That's done by the title insurance underwriters, which typically are large corporations like we write for Old Republic National Title Insurance Company. They're a publicly traded stock corporation, basically a massive mutual company. And what you think of as the title company is actually an agent for an underwriter, right? A big corporation who's insuring those policies. So you might have an old policy and you go, oh no, the title company went out of business. But the underwriter is most likely still in business and your policy is still good, even if the agent that issued it to you is not in existence any longer.
how long do the policies last?
So an owner's policy will cover you for the entire term of your ownership and that of your heirs. Okay. Obviously, upon, if you're selling it to someone else, they're going to have to purchase their own policy. With a loan policy or a lender's policy, that goes for the life of that loan. A lot of people go, hey, why do I have to have a loan policy? I'm not worried about that. That's protection for your lender. It doesn't protect you at all. It says, in the event there's an issue with the title of this property, we're insuring up to the value of the loan. So almost every conventional, well, as a functional matter, every conventional lender will require you to purchase a lender's policy that protects them. But again, that doesn't protect your ownership interest. That's protecting the lender's interest. And those policies may or may not be required with a hard money lender. It depends. I shouldn't say most. Some require them, some do not. It just depends on your hard money lender and what they're willing to accept. It's obviously, if you're looking to, you're an investor and you're looking to save money, if you have a hard money lender who does not require the purchase of a separate lender's policy, then you can, definitely save a few bucks there.
Gotcha. Well, I got a question on that. John and I and the boys, we buy from the auction a lot whenever we can, when the deal's right, and other auction sites. And sometimes you get title policy, sometimes you don't. We just have to do as much research as possible. But if you buy it at the auction and you wait your 10 days or 15 days, however long it takes them to give you your certificate of title, are you able to purchase a standalone title policy, or would you have to do another closing?
You can buy a title policy after you purchased. They're going to have to do a search on that particular property, and they're going to, just like if you were buying it at a sale, they're still going to do a title commitment to show you what's going to be exempt from coverage under that Schedule 2B, and then they're going to issue an owner's policy to you in the amount that you've purchased the property for. They will never let you purchase the property at the same time as you're purchasing it or right after for a higher amount than the property's worth. So
okay.
It's not like you can't buy a title policy for $1 million and go, oh, one day my property's going to be worth that.
Well, I was just thinking, because sometimes you don't know, something may be wrong, but you overlooked it. To us, title policy is gold. We try to get it on every single property that we buy because somebody's insuring the title, and that's the greatest part about it. So
in today's marketplace too, we've just gone through a foreclosure debacle where all kinds of defects have occurred. Mm-hmm. So if you've got a foreclosure in the case, generally the title examiner is going to have to not only look at the public records, but they're actually going to have to pull that foreclosure file to see if the appropriate parties were named in it, if the appropriate parties were served in it, and how their interest was resolved. And if there's any problem in that, it may be a defective foreclosure in that chain. And because of the volume of foreclosures we've had the last decade, it creates a big potential for bad titles.
Particularly, we see it, and it comes up a lot because the obvious cure to that is quiet title actions, right? And we see that a lot in the context of properties sold at the tax sales. We cannot insure the title to that right away without either going through a company who certifies those tax sales, which is typically a little bit more expensive than a quiet title action, but it's a little bit faster. Like, for example, there's one here locally called Clear to Sell. The other option is a quiet title action, which, if you're not familiar with what that is, it's basically a lawsuit where we file in the circuit court to establish who owns the property. So let's say I've purchased this property. We've identified, there's a defective foreclosure. I'm the plaintiff in this action, and I'm basically petitioning the court for an order that prevents any other parties from making a claim on my interest, on my title to that property.
Where's that most common? Tax deeds?
Typically, but just with the nature of what we see, because when from the real estate attorney side, we tend to see the most messed up properties you can imagine. So the tax deed situation is the most common. But we see properties that have been, particularly when people do their own deeds at home from forms they print off the internet, and we see quite a few quiet title actions that are required just because of how many screwed up deeds were recorded.
Corrective.
There you go.
We have Sam in Ocala. Sam Newberry, actually. I've known Sam for quite a while. He wants to know municipal lien search versus title search. What is the difference? Do you need both?
You do need both. If you do not have a municipal lien search, then any municipal liens like that are going to be an exception listed in your title policy. But you can think of it like this: the title search is really a search of the public records regarding that specific property, right? Is there a mortgage recorded? There could be a code enforcement lien that's recorded, in which case it's going to show up on the title search. However, what about the unrecorded liens? What about, the $500 in unpaid water bills and the current code enforcement action that's pending and the 50 open permits on the property? None of those things are going to show up in the title search, where they will show up in the municipal lien search. And the title company, after it's performed, can remove those exceptions from coverage and go ahead and ensure that those amounts are collected at closing. And it, at a minimum, makes you aware, hey, there's pending code enforcement action against this property. You need to address that with the seller. Because particularly in the investor context, code enforcement is always an ongoing problem, and unpaid special assessments as well.
Well, I just want to learn as much as I possibly can, because we're running across people that have done quick claim after quick claim, but yet they've had issues with other properties because, as I understand it, if you have 5 different properties in the same name and you got one code enforcement, you can't do nothing with none of those properties, but they'll try to do a quick claim deed just to get rid of it, but that's not good.
We particularly have been seeing that a lot with the city of West Palm Beach itself is notorious for this cross attachment of properties. Because a lot of times, you know, at one point, big hedge funds came in and all these kind of unusual purchasers and started buying up portfolios, basically. They'll buy 75 properties that are all kind of run down in West Palm Beach, and they mismanage them and forget to pay the taxes, and suddenly they want to sell it. And come to find out, they've got a code enforcement action for, you know, $2 million could be, and it's attached to all 75 of those properties. And if you're not aware of that, it can, you know, that would be a very unpleasant surprise to get, because the city will not sever that cross attachment until it's taken care of.
It's also one of the things these days that delays closings a lot of times that we didn't have to deal with historically. Because not only do you have to do a municipal lien search, but each city sets their own rate for what they're going to charge for that lien search. And some cities, you can expedite it. In a lot of cities, you cannot.
So basically, if you keep it separated, like the old song goes, keep it separated, you could have different LLCs that own the different properties. You could have them in a land trust, which I know it's not, you know, the greatest vehicle to transfer property, but it does keep it separated to some extent.
I've actually dealt with investors in the cross collateralization on this specific issue with West Palm Beach in the last couple of weeks. Mm-hmm. And the fact that they had it in a separate land trust was the only reason that the city couldn't cross attach and prevent them from.
Look at that.
It's just a very simple procedure with a simple paperwork, and that's something we're definitely going to expand on and teach in the future, because a lot of people are asking about it. And it's just simply a 12-page Word doc, and you put it all together, you get it notarized, and that's the owner of the property.
And in this case, the city tried to tell us that, oh, because the trustee was the same, they could cross-attach them. Mm-hmm. But after a brief discussion with the higher-ups, they were pretty clear that, no, that is not the case. Each land trust is a separate entity, and the trustee, you know, somebody like Bank of America might be the trustee on hundreds of properties. It doesn't give them any ownership rights.
Right. They're not the beneficiary, I guess, right? So that's probably
no, they are not. They're just acting as a, you know, as a legal title holder only.
Right.
John?
Well, yeah, so I wanted to bring up one other thing Evan touched on. You were saying how, you know, everybody and their brother knows somebody who, you know, works at a title company, or do title companies all charge the same policy premiums, I guess, right?
So, yes, there is something called the promulgated rate. It's put out by the state of Florida. It tells you basically what the title insurance policy is going to cost. The difference being that, okay, so we charge the same policy premium rate as, you know, basically everyone, well, actually everyone in the state of Florida. The difference being the settlement fees, you know, all the additional fees that title companies end up tacking on are specific to those title companies. So you think, oh, any title company is good, you know, it's all going to be the same fees. It's not. That's just the policy premium fee. That's the price of the insurance. That's not the price you're paying for the service they do for you. So it's important to shop around and work with a company that, particularly because we work with investors, we hear the nightmare stories of people who work with title companies that aren't familiar with investors, and it can be an education for the title company in trying to handle some of the issues that we experience on these investment deals and just the way the contracts are structured.
Oh,
You know, a land trust is something we see more often than not, where for the title company down the block in the strip center may or may not be familiar with them and may or may not be willing to close that transaction.
I've had title companies not be willing to close assignments and stuff like that, or not know what I'm talking about. So yeah, I guess investor friendly is very important.
Oh my goodness, yes. There was this one title company, I would love to mention their name, but I'm not going to. And we attempted to close a standard purchase from our little cookie cutter neighborhood, and they did not understand the land trust at all whatsoever. And we had to argue with them. They were trying to, no, just put it in your personal name and deed it over later. Make it easy. No, that doesn't make any sense. So I'm just glad you guys know what you're doing. You guys are awesome, and we do all our business with you, and there's a reason for that. And basically, investors out there will buy your deals, will buy anybody that has a deal, and we're going to use this title company because we want to make sure it protects us and it protects you guys, the sellers, as well.
Both attorneys too.
Oh yeah.
And Jeff, to touch on another issue that just came up. If you do buy a title policy, you want to make sure that you read it and make sure that it allows you to transfer it. Let's say you want to, at a later date, you say, oh, they required me to close it in my personal name, and now I want to transfer it to my trust or to my LLC or to my corporation. You want to make sure that your policy allows for that, because we've seen situations in which case people go, oh, I'm going to close this in my name and I'm going to transfer it here. And when you look at the policy they got, it will cut off their coverage because, hey, we didn't insure your trust. We insured you personally. And the trust is a whole separate entity from you. So it's something that people need to be aware of. And you got to read these things, even though they might not, it might not be the most exciting part of your day. It's going to pay off in the long run.
Okay, so we got one more. We got this guy named Hal Simpson, and he is in Jacksonville, and he wants to know the importance of getting a survey. Why can't you just look on Property Appraiser and it's got the lines on it? Is that good enough?
Well, you don't have to have a survey. What the advantage a survey provides you is in a standard title policy, it has an exception saying anything that would have been disclosed on a survey, we're not covering, right? We're not guaranteeing unless you got that survey. So if you get the survey, you can go ahead and remove that exception, and they're now covering to ensure that there's no encumbrances or somebody violating your kind of property lines. So when you have the survey, it is an optional thing, but it's a good idea, particularly if it's going to be a buy and hold, to make sure you have that coverage. Obviously, in your flips, I mean, you have to make a personal decision, and kind of your own experience might be able to answer some of those questions. Sometimes you can get an older survey from when the person that's selling the property bought the property, and look at that and compare it to what you see today. But oftentimes the survey is, a couple $100, and if you're going to be holding the property long term, it's a big deal to be able to remove that exception.
Well, I put some money out recently on a property up north as a lender, and come to find out it's a large parcel, and they didn't pay attention to where the driveway was, so they don't really own the driveway.
Oh.
So they're trying to trade with the neighbor to trade part of the barn in the back, and it's interesting. I'm sure it's all going to end out, it's going to be fine at the end. But I always say it's when you do something like that, you're going to a seminar, because in this business, we learn through transactions every single day. As a matter of fact, we took over a subject to the existing financing deal a while back, put the deed into the trust. The bank was happy. We got it caught up, but the minute we got it caught up, they put the prepayment penalty back on. So here we were with a payoff, and then they put the prepayment penalty another $5,600. So I still walked away with about 12 grand, but I should have walked away with 17.6. So I went to a seminar. I learned.
No matter how many deals you've done, you learned a little something new every time.
I always say, as long as it has a plus in front of it, you're doing good.
Yeah.
Those are my words.
Yep.
What else do you have, John?
I think that pretty much wraps it up. I think, unless you have any other questions from anything, Jeff, or.
No, I think it was amazing. I did learn something. What I learned was the fact you buy title policy and it may have a cap on it. That's interesting because your damages could be a couple $100,000, but if your cap is 100, that's definitely something I want to check into. And the fact that when you buy property at the auction and you can get title policy just to make sure everything's good afterwards prior to a sale, that is interesting because normally I would just keep it and then figure it out when I go to sell it. But that's usually not the greatest time, but it's great to know you can do these things up front. This is wonderful.
Yeah.
Really learned a lot.
And everybody, make sure you pay attention to your HUDs from your other title companies and make sure you look at, their nickel and dime fees and what they're charging you. And, shoot the HUD over to Evan, and I'm sure Evan will tell you, how much money he could have saved you.
Oh, Deborah Newman wants to know how to get a hold of Jimmy and Evan. Well, it's so easy. It's sunshinestatetitle.net. Do you want to give out any further contact information, guys?
You can go on the site on sunshinestatetitle.net, and it has our phone number, which is 561-296-3252. And you can ask for either one of us, and either one of us would be happy to speak with you.
So as far as services, simultaneous closings, assignments, wills and trust, asset protection, estate planning, besides that, deeds, just anything really real estate related?
My dad always likes to say, we all give him a hard time. It's his catchphrase. If it deals with dirt, we've done it. I grew up here. He grew up here. Our family's been here for a long time. So even if it's not something that we do, I can generally direct you to someone who does that. And we're happy to do that, particularly because attorneys have gotten so specialized. It's a good sometimes you just don't know. I didn't know there was a specific attorney for this, but if I can direct you to someone, I'd be happy to do so.
That is fantastic. And we have our awesome Crazy Buffet lunch meetings. We had 72 people. We have it on the 2nd and the 4th Friday, and that thing is growing like crazy. And that's where you can see the attorneys, the representatives from even our insurance company, Sunshine State Coverage, a John Gall agency. John, what's our contact information?
So you can go to palmbeachreia.com to find any of the company's information, websites, phone numbers, also nationalreic.com. And remember to tune in to every Tuesday, 7 p.m. We're going to do one of these live interactive podcasts for you guys. And that's about it.
I really learned a lot, and we're going to do this again in a few months. And I'm sure we're going to have more questions because, in our everyday transactions, we run across everything. And I was talking to John, I think it was either yesterday or today, and he was asking me questions. What should we do here? And I'm like, oh, give it to Evan, give it to Jimmy. I don't know. Let them worry.
I called Evan earlier today with a question with a property because it was both. What was it, Evan? I think both of the only two deeds.
It was a couple of messy at-home quitclaim deeds. We're making it unclear, and along with one of the individuals needing a guardian or having a guardianship, making it unclear on who exactly owned a piece of property.
So. Well, I'm glad we got you guys in our corner, and we're very, very, very happy to have you guys, and we're going to have a bright, bright future. And I'm sure we're helping so many different people with the lunch meetings and the podcast and just having a great title company and great attorneys at the title company. So I thank you all and have a wonderful evening.
Yep.
Thanks, guys.
Thank you, everybody. And remember, tune in every Tuesday, 7 o'clock, and we'll have a new guest on for you guys. And have a good day or a good evening.
All right. Thank you. Good night.
Good night.